Science has led to incredible technological progress and an increase in our standard of living, but it has also led to some pretty nasty discoveries. Regardless, we all probably think of science as a neutral and reliable source, right? Well, there's been many philosophers over the years who have critiqued the objectivity of science, so to speak. But these are just some nerds sitting around at home being abstract, right? Practically speaking, we need to treat science as always neutral and correct. Well, in this video, we're going to be looking at philosophy in practice, specifically in the area of law, and see how the US Supreme Court has questioned the complete reliability of science. The case in question is Melendez-Diaz versus Massachusetts. Now, before we get into any high-level legal questions, each case contains a series of facts that explain what happened. So we're going to first find out who Melendez-Diaz is and why Massachusetts has a problem with him. The year is 2001 and the place is Boston. Police receive a tip that a Thomas Wright is acting kinda suspicious. So police set up cameras in the Kmart parking lot where he worked. They saw him get out of a car, detained him, and searched him, finding some bags on him that contained a white powder I probably can't mention on YouTube. There were two other men in the car who also got arrested, one of which was Luis Melendez-Diaz. After searching the car further, they found 19 other plastic bags with the white powder, and then they sent these bags to a lab to do a chemical analysis to see if it's really the substance you're all probably guessing it is. So Melendez-Diaz is tried for distributing and trafficking substance C, let's just call it that. The prosecution submits these certificates of analysis done by the lab, saying that they tested the substance and it is in fact substance C. But the prosecution only submitted these certificates. They didn't call any of the lab workers to actually take the stand to testify about their findings. This is a problem. Why? Because of the Sixth Amendment and more specifically the Confrontation Clause. The Confrontation Clause essentially says, look, if someone's making a claim and that claim is going to be used in court, a defendant in a criminal case has the right to question them. Let's say you're on trial for murdering person A, and I sign a piece of paper stating that I saw you kill person A. I could be lying, I could be unreliable, or I could just be dumb. So you, the defendant, should have the right to bring me into court and really question me before we just accept that I'm a reliable witness. In all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. So does this certificate stating the lab results bypass this constitutional requirement? Massachusetts argues yes. And one of the reasons is because they believe science is neutral and reliable. Sure, eyewitness testimony may be shaky, but science? Come on, science can't be wrong. So why burden the court with getting the people from the lab to testify? Well, the lower courts agreed with Massachusetts, leading to appeals and appeals until we finally get to the Supreme Court. The final say in the matter. The justice writing the opinion is Justice Antonin Scalia. And if you're a political person, your alarm bells may be going off favorably or unfavorably, but don't worry, because he's joined in this opinion by Ruth Bader Ginsburg. So this is not really a politically divisive or charged opinion, since this is a rare case where they both agree. Scalia starts by summarizing the state of Massachusetts' argument. Respondent claims that there is a difference, for Confrontation Clause purposes, between testimony recounting historical events, which is prone to distortion or manipulation, and the testimony at issue here, which is the result of neutral scientific testing. Now might be a good time to introduce you all to a very common form of legal analysis called IRAC. No, not the country Iraq, but IRAC. IRAC stands for Issue, Rule, Analysis, and Conclusion. The issue is the overall legal question the court is trying to answer. The rule is the answer to that question, which can be applied broadly. The analysis applies that broad rule to these specific facts, and the conclusion, well, concludes about this specific case. So the issue in this case is whether scientific findings are still subject to the Confrontation Clause. It's our general question that we could apply to other cases. The rule, spoiler alert, is yes. Scientific findings are still subject to the Confrontation Clause, meaning the defendant in a criminal trial is still allowed to confront the scientist who conducted the research or test. Next is the analysis, which is really where the philosophy comes in. Scalia starts by stating that scientific testing is not completely neutral, nor is it evident that what respondent calls neutral scientific testing is as neutral or as reliable as respondent suggests. Forensic evidence is not uniquely immune from the risk of manipulation. Scalia cites a study saying that the majority of forensic labs are administered by law enforcement agencies. So there's a pretty clear danger of bias here. I mean, in any line of work, if you're requested to do work for someone, there's a pressure to deliver a product that the client will be happy with. A forensic analysis responding to a request from a law enforcement official may feel pressured or have an incentive to alter the evidence in a manner favorable to the prosecution. We could apply this more generally and philosophically, saying that the search for any empirical knowledge may be tainted by what you're hoping to get out of it, and even just looking at pre-existing data or observations may be influenced by confirmation bias. But this is not limited to intentionally fraudulent scientific research. The confrontation clause is also there to address mistakes and error. The people conducting these scientific tests are people. They're prone to making unintentional mistakes. The confrontation clause allows the defendant to question the methodologies used so that we could really be certain that the evidence is reliable. After all, lives are on the line here, and bad evidence could be detrimental. One study of cases in which exonerating evidence resulted in the overturning of criminal convictions concluded that invalid forensic testimony contributed to the convictions in 60% of the cases. So Scalia and the majority are not anti-science, but they're being skeptical about the complete reliability of scientific testimony. Funny enough, Scalia himself mentions 2 studies I talked about, so again, it's not like he's anti-empiricism, but just cautious. Now we could take this out of the court setting and apply this to our lives as well. We don't have to be anti-science, but we don't have to blindly accept scientific findings as well. We could question the methodology, the scientists' biases. We could really get into the reasoning behind a finding without blindly accepting that finding in the first place. There is little reason to believe that confrontation will be useless in testing analysis' honesty, proficiency, and methodology, the features that are commonly the focus in the cross-examination of experts. And that right there is our analysis portion. Finally, our conclusion is that Melendez-Diaz has the right to cross-examine the lab workers responsible for these findings. So hopefully this was a good example of how philosophy can be put into practice, specifically in the area of epistemology. As a bonus, this also goes along with the last 2 videos on intellectual humility. Don't believe that science is completely infallible, because those behind the science are human after all. I remember reading this case during my 2nd year of law school and thinking it might be a good fit for the channel. But there's other things from law school that might also make good videos, so let me know if this worked for you. If you enjoyed this video, then be sure to like, subscribe, and hit the bell button for more philosophy videos. And with that, I wish you all a beautiful rest of your day.